Hello, and welcome once again to Lehto's Law. I'm Steve Lehto, attorney at law in the state of Michigan, where I'm practicing on it for 25 years in the fields of consumer protection and lemon law. I often heard about this stuff for places like roadandtrack.com. And today we're going to talk about the top 5 things most car buyers miss in the paperwork when buying a used car. I talk to people all the time. I've spoken to thousands of used car buyers, and I often hear that they've missed things in the paperwork, and I realize it. And of course, it's too late to do much about it, but so I'm going to try to tell you about the top 5 things most car buyers miss in the paperwork when buying a used car. Next time you go shopping for a used car at a dealership, watch for these 5 things in the paperwork. Number 1, the arbitration clauses. These are popping up more and more these days. A lot of used car sellers are becoming quite savvy, and they're putting arbitration clauses in their purchase agreements. They often put them on the backside even. And you don't want to commit to arbitration because quite often not only do they make you go to arbitration, but they choose the forum. They'll actually say you've got to arbitrate with this group or that group. And sometimes these different arbitration groups cost more than filing a lawsuit. And they often have rules that are in favor of the big businesses. Many of these companies actually advertise on the internet that they are good for business, wink, wink. And that's what they're basically telling people is, look, if you're a business and you push people to arbitrate with us, we'll rule in your favor. And people have been complaining quite a bit about this because arbitration clauses are often hidden in other contracts with like the cable company or credit cards and so on. But there should not be an arbitration clause in the purchase agreement for you to buy a used car. So if you see an arbitration clause, negotiate it out or shop someplace else. So the arbitration clause is the number one thing people often miss nowadays when buying a used car. Number 2, this is becoming more common lately. I don't remember ever seeing this until about 10 years ago. But the shortened statute of limitations. And here's the deal. Every lawsuit that's potentially filed, there's a time frame within which you must file it. All causes of action, all legal lawsuits have got statutes of limitation that say that, if you're going to sue somebody for a breach of contract in Michigan, you get 6 years to sue them. Or if you're going to sue somebody for slander or libel, you get this long to sue them for. And it varies from cause of action to cause of action. Well, the Uniform Commercial Code, which governs the sales of goods in most states, says specifically that you've got 4 years from when your cause of action arises to file your lawsuit. So 4 years is a good length of time to discover if the product you bought is defective or it's whether the warranty's been breached and so on. But the UCC has a subclause that says that the parties can, by agreement, shorten it to as little as 1 year if they do it in writing and they agree to it. So what a lot of car dealers are doing now is they stick a sentence in the document someplace that says, oh, by the way, the parties here to agree that any cause of action arising from this transaction must be brought within 1 year of the purchase date. And they'll often say 365 days or 1 year. But that's the shortest that the UCC allows to be shortened to. The problem I have with it is that most people don't know what that means. They don't even think about it, and they're unaware of the fact that they're basically just limiting their ability to go after somebody if, in fact, they got ripped off. Now, it's true that most rip-offs will be identified within 1 year of purchase. But I've seen the shortened statute of limitations hidden in things like purchase agreements for $250,000 motorhomes. So if you're buying a used car, and you see that in the purchase agreement, number 1, try to negotiate it out. If they refuse to negotiate it out and you really want to buy that car, then buy the car, but understand that if you have a problem with it where you need an attorney for whatever reason, if you call an attorney 13 months later, you can't do anything about it legally. You're limited to 12 months, 365 days or 1 year. So look at the shortened statute of limitations and ask yourself if you're willing to live with it. If you are, that's great, but be aware that it's there. And that's the problem with a lot of this stuff is many of these things are not fatal. It's just simply that you should know about them and enter into these agreements understanding what you're getting yourself into. The third thing that people need to understand, and this is written on every purchase agreement I've ever seen in my entire life, is that statements made by the salespeople are unenforceable. And it will say that on the purchase agreement. It'll actually say, statements made by the salesperson to you are not enforceable unless they're reduced to writing and put on this document, and they never are. So people call me, they say, Steve, I bought a car, I bought a widget, I bought anything, doesn't matter. I bought something. And the salesman said something to me. And I say, well, did he write it on the purchase agreement? They say, no, but he told me such and such. And I say, it doesn't matter. They say, why not? And I say, because the purchase agreement says statements made by the salespeople are unenforceable. And they say, well, how do you know that? You haven't seen my purchase agreement. I said, I've seen them all. They all say that. That's something they all say now. And once you've signed a document where you say, I acknowledge that statements made by salespeople are unenforceable, you need to stop saying, but the salesman said such and such. Because whatever he said, it doesn't matter. It's unenforceable. They can say anything to you. And that's one of the things I talk about quite a bit on this show, is that you need to understand that when they're talking to you, you can ignore everything they say. Now, if they say, I agree with you, we're going to sell it to you for such and such a price, obviously that's good because they will put that on the purchase agreement, assuming that they stick to their word. But anything else they say to you, unless they give it to you in writing, it doesn't count. Due bills are another thing. Obviously, if they say, hey, by the way, if you buy this car, we'll fix this, which to me is funny because you should just say, why am I going to buy a broken car on the promise that you'll fix it? Why don't you fix it first, then sell it to me? But I digress. So if they put it to you in writing on the due bill, it's enforceable because it's in writing. So remember that statements made by salespeople are unenforceable. And when you sign the purchase agreement, that should remind you, oh, by the way, everything they just said to me is unenforceable because I'm signing a document saying it's unenforceable unless it's reduced in writing to this document, which it's not, right? Never is. So understand statements made by salespeople are unenforceable, and that's in writing on the document you just signed when you bought the vehicle. Number 4, you need to understand the as-is limitations, and this is something people miss in the paperwork. And people don't realize that in the flurry of paperwork at the vortex of closing when you buy the vehicle, there's a buyer's guide, a Monroney document. And the buyer's guide says right on the front, this vehicle is being sold to you either as is with no warranties or with a warranty, and it's described here. Most used cars sold in states that allow as-is sales are sold as is. An overwhelming majority of them are sold as is. So people will buy a car, they will see that buyer's guide. Some places will even have you sign it. They'll be driving the vehicle and something will happen. The engine will explode, the transmission will scatter, the differential will grenade. And they will then call me and say, Steve, I bought the car and within 24 hours, the engine exploded. And I say, okay, so what? You bought it as is. They say, well, aren't I guaranteed some time? No, you're not. First of all, you're not. There is no 24 hours or 72 hours or 100-yard rule. And I know there's a lot of misunderstanding on this because when I wrote columns about this for Jalopnik and Opposite Lock, where they allow comments beneath the articles, I had a lot of people chiming in saying, well, in our state, you get 3 days. No, you don't. There's no state that does that. In our state, you get 24 hours. No, you don't. In our state, you get 100 yards. No, you don't. There's no distance or time limitation within which your car is guaranteed not to explode. And people say, well, Steve, obviously, if I bought a used car, but it's brand new to me, and I haven't even gotten in it yet, no. If you sign the purchase agreement and they hand you the keys, as you're walking towards the car you bought as is, it could explode right then and there on the lot. You never sat in it as an owner. It's still your car. The paperwork was completed. The car is yours. And people say, well, Steve, that's not fair. Yes, it is, because what you missed in the paperwork is the backside of the buyer's guide. And the buyer's guide on the front says, see the backside. You turn it over and it goes, here are the things that could go wrong with your car. And it lists things such as the engine having a cracked block, the transmission having a cracked transmission case, and so on. And it lists these catastrophic failures. And I've had people call me before who don't believe this and they don't want to believe this. And they say, Steve, I bought a car. I was driving it the first day. I was driving home from the dealership and the engine exploded. And I say, okay, but you bought it as is. There's nothing you can do. They say, well, that can't be. I mean, I was just driving it home. I hadn't even gotten it home yet. It had temporary plates on it. And I say, yeah, but the documents you signed tell you that you don't have a case. They say, that's not possible. I say, yeah, it is. Pull out all your documents. Do you have a copy of the buyer's guide? They say, yeah. I go on the front, it says as is, right? And I say, yeah. I go turn it over in the back. Read the list of things underneath engine that can go wrong with that car. One of them is what you're describing to me. And they say, well, I didn't see that. Well, that's why I'm talking about it today. It's something people miss in the paperwork when buying a used car. So, again, I've talked about statements made by the salespeople or as-is limitations. But the bigger problem here is that all of this stuff is in the documents that you sign at a dealership. It's just that people miss this stuff. And the reason they miss it is because you're signing dozens and dozens of documents. and the salespeople are talking to you and telling you things and promising you things, all of which are unenforceable, and they're causing you to not pay as much attention to what you're signing, and it's probably even physically impossible to read every single word of every single document they have you sign within the time allotted, meaning that you couldn't do it in one day at a dealership. Take a look at a typical lease agreement, just a lease agreement. It's usually 8.5 by 17, double-sided with fine print on the backside. It would take the average adult an hour to read that document and actually comprehend it. That's just one document. But I'm pointing out these things to you, so next time you're at a dealership buying a used car, you should at least go, hey, that's the 1-year statute of limitations that guy was talking about. That's the arbitration clause he was talking about. Or here's the last one, number 5, unknown add-ons. So everybody knows you go to a dealership, it's a painful experience. Most people would rather go to the dentist. You go to the dealership, you walk around, you find a car you like, you kick the tires, you slam the doors, you take it for a drive, it doesn't explode. You even take it to your mechanic who does a full inspection for you. And after doing a full inspection, your mechanic goes, hey, this thing's bulletproof. I like this car. This is a good deal. If you don't buy it, I will. So you go back to the dealership and you say, I want to buy this car for $20,000. They go, we want to sell you the car for $20,000. And $20,000 becomes the number on line 1 of the purchase agreement. And everyone knows that there's a bunch of other numbers that fall below it, a stack of numbers or a column of numbers. And at the very bottom is a total cost to you, okay? Here's the problem. Everyone knows that the number 1 thing we think about, line 1, is the price of the car. And there's a bunch of other numbers underneath that, and we generally know that they're going to make this number 1 number get larger, okay? So you buy the car for 20, the bottom number there is 25. Sounds about right? I mean, tax, title, documentation fee, other unknown fee. But quite often what they do is they'll slip in things for add-ons that you don't have to buy. And if you spot them, you can say, hey, what's that doing there? And I'll give you an example. Credit life disability insurance, or it'll often be abbreviated CL/D. And I know that there have been several car dealerships that I've encountered in my career who sold credit life disability insurance to every single person who walked in their door. New cars or used. Didn't matter. You buy a car from them, there's going to be a line that goes CL/D, $200, $300, whatever it is. And most people go, let's see, the tax in the car is 6.5%, title, transfer fee, license plates, registration, and there's another $200 in there. They don't really catch it. And because it's got an abbreviation, they don't know what it is. And there have been situations before people bought that insurance not knowing they had it. If you don't know you have it, how can you use it? And I know this is a little abstract, but if I sold you a car that had a radio in it that was AM, FM, it's one thing. If I sell you a car, and I know I'm doing old school stuff here. If I sell you a car that's AM, FM, and it has a cassette deck in it, at least when you buy the car, one day you go, hey, it's got a cassette deck. And you could use the cassette deck if you had cassettes and you felt like listening to them. But if you got the credit life disability that's been sold to you on the purchase agreement, but you didn't know you had it, if you became dead or you became disabled, no one would know to file a claim on your behalf. So it's useless. It's literally useless unless somebody goes through your papers after you've passed away and said, hey, wait a second, he's got credit life disability. But they're never going to notice that because it just says CLD on one line of one document, which they're not going to be looking at the purchase agreement of the used car you bought while they're going through your estate. But the point is that they will stick things in there hoping you won't spot them. And they know that most people will only focus on line 1. It's a $20,000 car. Boom. That's fine. I'll pay the $28,000 to get out the door, or $26,000 to get out the door, whatever it might be. Among the things I've heard of being added onto cars besides credit life disability insurance are things like fabric protection, paint sealant, rust proofing, and these are things that no one in their right mind buys today. If you actually buy fabric protection from a dealership, they'll have a technician take a can of Scotch Guard and spray it in your car to make it smell like something's been sprayed in there. You can go to Home Depot and buy fabric protection, Scotch Guard if you want to, but you don't need it. Or paint sealant. Now, car companies have been painting cars now for about a century. Painting technology has gotten to the point where the paint is sealed from the factory. If you really want to seal your paint, wax it yourself. But the paint sealant that they put on your car, which probably doesn't mean anything, does nothing. It's money being thrown out the window. And likewise with rust proofing nowadays, okay? You don't need to get a car rust proofed. No. The rust proofing will do nothing except probably damage your car. In fact, that's why you hear so little of them. They don't advertise rust proofing anymore. Remember, it's us or rust. You don't hear those ads anymore because rust proofing has fallen by the wayside. And yet I've still heard of car dealerships that sell rust proofing. So when you're going through the purchase agreement, going down that column of numbers, you'll recognize some of it. But if you don't recognize some of the numbers, ask. I mentioned before, I leased a car in Genesee County, and they put a pinstripe down each side and charged me $75 for it. And I said, I don't want the pinstripe. They go, we can't take it off. And I said, well, I didn't tell you to put it on. They said, well, we pinstripe all our cars. And in fact, pinstripe was a line that was pre-printed on their purchase agreements. This dealership ripped off every single person who bought, leased, or got a car from them in any way, shape, or form. And they charged you $75 for pinstripes. And I said, I'm not buying the car with the pinstripes. And I sat there like this, and they said, we're not selling you the car without pinstripes. And I said, really? They said, yeah. Well, foolishly, I bought the car. I should have, to prove a point, and so I could have a better story to tell you, I should have gotten and walked out. But there's a reason I got stuck with that car, which I won't go into now, maybe a later episode. But the point is that they were ripping every single person off for $75. And that's just what they do. Now, that was not an unknown add-on, but a lot of people wouldn't have spotted that or wouldn't have cared. It's only $75. Because when you're looking at a $20,000 top line or $25,000 or $45,000, $200 doesn't seem like much. But when they do it to every single person who walks in the door, it adds up for them. But also, that $200 is $200 or whatever it might be, $75, okay? So the unknown add-ons, go through the column of numbers and ask which every single one of those numbers is. And don't be surprised if they have something in there that you can say, I don't want that. Cross that out. Oh, we assumed you wanted it. Everybody wants that. Why wouldn't you want that? And of course, I'm sure you know it's illegal for them to tell you that you have to have the credit life disability to get a loan. They also used to do that one also. So be aware of that. Top 5 things car buyers miss in the paperwork when buying a used car. Arbitration clause. Number 2, the shortened statute of limitations. Number 3, statements made by salespeople are unenforceable. Number 4, the as-is limitations. And number 5, the unknown add-ons. Those are the top 5 things most car buyers miss in the paperwork when buying a used car. Questions or comments, shoot them my way. LehtoSlaw.com, LEHTOSLAW.com. I'm on Twitter, at Steve Lehto, at STEVELEHTO. And this show's on iTunes, Stitcher, SoundCloud, Podbean, Google Play, everywhere else, and YouTube. Thanks for watching and listening. Bye-bye.